May it please the Court. My name is Craig Clausing. I'm a Senior Assistant Director at the Office of Lawyers' Professional Responsibility, and I'm appearing today on behalf of the office in the petition for disciplinary action against Attorney Jill Clark. The Court directed that arguments be heard today on the recommendations of the referee assigned to the underlying disciplinary case. Specifically, the referee made three recommendations. First, that respondent be placed on disability and active status. Second, that the disciplinary proceeding be stayed during the disability. And third, that issues of respondent's asserted disability and inability to assist in her defense be referred to the referee for further findings. The Director concurs with the referee's recommendation as to the first two and urges the Court to adopt those recommendations, that respondent be placed on disability and active status, and that the disciplinary proceeding be stayed. As to the third recommendation, the Director agrees that a hearing would be appropriate, and I'm not sure that we actually disagree with the referee's recommendation. Perhaps it's just not clear, but that hearing would be conducted as part of a reinstatement petition. That would be the proper venue for that. There's some issues with conducting it in another manner, and I'll discuss those a little bit later in my argument. First, I think it's important to note for the record that the Director's office was not seeking, did not petition to place respondent on disability and active status. The Director was prepared to and wished to move forward with the disciplinary case on Monday, June 25th of this year. It was scheduled for trial at that time. It was respondent who asserted a disability and who was unable to assist in her defense. When an attorney in a disciplinary proceeding asserts that he or she is disabled, Rule 28 governs such an occurrence. Rule 28 of the Rules on Lawyers' Professional Responsibility provides a number of options to the Court. The first one listed and the one recommended by the referee was that the attorney be placed on disability and active status. Now, Rule 14 governs, Rule 14 again of the Rules on Lawyers' Professional Responsibility, governs hearings on petitions for disciplinary action, and pursuant to Rule 14C, the Court accepts the referee's factual findings as conclusive. In challenges to those findings, the standard of review for this Court is whether the referee's findings and conclusions were clearly erroneous. And the Director submits that they were not. The referee heard from respondent's husband prior to the commencement of the hearing, specifically on June 21st. There was a telephone conference scheduled on that day, and her respondent's husband appeared in her stead, and as the referee found, he stated that respondent was, quote, unable to properly prepare or participate in the hearing due to her condition. At the hearing, which was commenced nonetheless on the 25th, respondent did not appear, and the referee received additional information from respondent's Health East Care team, which stated that she had been hospitalized since June 21st and was under the care of her physician, and that she should be excused from any appearances or other work. Also at the hearing on the 25th, both respondent's husband and her counsel indicated that due to her present condition, respondent was unable to assist in the defense in a disciplinary proceeding. Now, the referee also considered respondent's conduct prior to the hearing, as the referee found respondent had submitted some rather strange findings and arguments. His quote, those findings included a witness list which had 186.
I have a concern, and that is maybe the best way for me to put it is whether is there any medical evidence of a disability, and by that I mean a diagnosis made by that's based on competent medical testimony that Ms. Clark is disabled. I know we have some allegations, and my concern is that there's no medical testimony here to guide the Court, and it seems to me that what may be a better fit is Rule 28C, and I'm wondering that, I mean, that is one where there is an assertion of disability in a disciplinary proceeding, and I'm wondering what the Director's position is with respect to the lack of medical testimony here.
Your Honor, first, there is medical testimony. There's not a diagnosis of a specific illness, but I believe it's Rule 28 of the Rules on Lawyers' Professional Responsibility, Rule 28A, where a lawyer asserts a disability, doesn't require a finding of a specific disability, a specific diagnosis. C, concerning a disability asserted during a proceeding, again, doesn't require a specific diagnosis. It's that the lawyer asserts that the lawyer is disabled. And also, in this case, there is medical information, the Health East report. Is the record as extensive as we see in some cases? Clearly not, Your Honor. But I would also point out,
looking at 28A, it seems to require a conclusion that there is a mental illness, a mental deficiency, and I don't see that the evidence would support that sort of conclusion. There is certainly, if you will, an admission by Ms. Clark's husband that she has these problems. There's some hospital records, but there's no doctors or no indication that a doctor has testified that he, for example, examined the patient and that she has this condition and that she has this disability. And I'm just wondering where the competent evidence is that would support a conclusion that there is a mental illness that is causing or that is preventing the lawyer from competently representing clients.
Your Honor, I want to make sure I address all your questions. I think that there maybe were a couple in there, and please bring me back if I miss some. I believe I heard you say, wouldn't this be more appropriate under 28C? And in fact, it would be, and that's what we're proceeding under. The referee's recommendation, finding number one, or recommendation number one, is that Respondent Joe Clark be immediately transferred to disability and active status pursuant to Rule 28C. And that is what we're proceeding under, and we believe that's the appropriate rule provision, that it was in the context of a disciplinary proceeding that Respondent asserted. There wasn't an allegation from the Director's office, and that was the point I was attempting to make earlier. There wasn't a Respondent by the Director's office that there was a disability. Rather, it was an assertion by a Respondent that she was disabled and unable to participate in the proceeding. And yes, the medical evidence is limited as to the extent of the disability, but I suggest that the Court has to review this in the totality as the referee did, and that is looked at Respondent's conduct, looked at the limited medical information that it had, looked at the rules, considered statements by Respondent's counsel, and based upon that concluded, the Director submits correctly, that Respondent was under a disability and unable to participate in that disciplinary proceeding and therefore should be placed on disability and active status. One final point on the medical record. While there's not extensive medical information as to the disability, there's really no medical information showing that there isn't a disability. A disability had been asserted. There were clearly some issues of problems. There's no medical information in the record showing that Respondent is no longer suffering from a disability, and that record could properly be developed, again, as part of a petition for reinstatement. Did I hit all your questions? I mean, I may not have satisfactorily answered all of them, but did I at least address all of them?
Well, it's helpful to, so the Director is proceeding under 28C, which to me means that we need to have a hearing as to the nature and extent of the disability. And I just want to make sure that I understand. When you mentioned that there would need to be a petition for reinstatement, it's not exactly the way that I understand how this would proceed under 28C, but maybe I'm misunderstanding the Director's position, because it seems to me the Court would have the authority under 28C to direct that there be this hearing and that we make sure that that we proceed accordingly.
Your Honor, and that